All right, y'all. Peace and love, peace and blessings. Hope y'all doing well out there. It's gonna be a short video. I'm not gonna go too long on this thing here. Shout out to Sophia Stewart, the original concept creator of the Matrix series as well as the Terminator series. I don't own this image. This image belongs to the Matrix franchise, but it's used to go into, or to show you what we're about to go into in regards to why blood is going to be important in regards to what they're getting ready to do to the people. And the masses have no idea what's in store for their asses. As you can see, Neo is waking up. He breaks up out of his pod and he sees he's been living a lie his whole existence inside that pod. And basically he also sees everybody is in a state of suspended animation as to where they're living their whole lives in pods, and the only thing that's active is their mind. The body and everything else, including their thoughts, are all controlled, the whole nine. This COVID-19 scenario that they're playing out on y'all, this scripted scenario, is basically a furtherance of their agenda, the powers that want to be, to eventually get y'all to a state where you're nothing but a mindless automaton. And eventually corporations are going to have patents and ownership of your asses. You're going to be on somebody's corporate plantation if your status is not correct. So this is the reason why status is everything, man. And not only that, in regards to you sanguinists, law of blood, rights of blood, that is the highest that one can get, for the simple fact that the Most High is the one who creates heirs or creates the bloodlines, not man. So there are a lot of people out there, man, that have came up with spin-off concepts and knockoff concepts of what I was the first to do. The first to redeem the bloodline to the land. And the public records prove that. Anybody else out there making that claim, ask them to show you the record. And we're going to go into that a little bit later, the dates, so you can see it yourself. Because it's claim and proof of claim. And you got to make these people prove their claims. So let's get into it. Alright, y'all, this right here is the Organization of American States, American Declaration on the Rights of Indigenous Peoples. Alright, we're gonna go through this thing. I'm gonna show you some things. Where is this drawing its source from? Let's take a look. This is for y'all fools who try to challenge me in the difference between the Organization of American States, American Declaration on the Rights of Indigenous Peoples, and the UN Declaration on the Rights of Indigenous Peoples. As you can see, it's relying on the United Nations Declaration on the Rights of Indigenous Peoples. Here it is right here. Let's see what else it says. Nothing in this declaration may be interpreted as implying for any state, people, group, or person any right to engage in any activity or to perform any act contrary to the Charter of the Organization of American States or the Charter of the United Nations, or construed as authorizing or encouraging any action which would dismember or impair totally or in part the territorial integrity or political unity of sovereign and independent states. full effect and observance of human rights. This is still the Organization of American States document, the AMDRIP. Indigenous peoples and individuals have the right to the full enjoyment of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Charter of the Organization of American States, and International Human Rights Law. The United Nations is mentioned 7 times in this document. United Nations, United Nations, United Nations Declaration. Rights of indigenous peoples. Rights of indigenous peoples. Let's see what it says about genetics. Here we go. Article 28. Protection of cultural heritage and intellectual property. Y'all see it? Y'all see it? Genetic resources right there. Traditional knowledge associated with genetic resources. And there you have it. This here is the United Nations Declaration on the Rights of Indigenous Peoples. See what it says about genetics. Article 31. Make it bigger so y'all can see it. Make no mistake, so you can peel your peoples back and see for yourself. Article 31. Including human and genetic resources. There you go. Right there. Now, don't ask me why I deal with DNA. It's quite obvious. And it's also obvious. Wouldn't you think that if they put it in 2 documents dealing with indigenous people and their rights, that it's important, and blood is the highest law, the laws of evidence, incontrovertible evidence? I'm going to let that hang in the air for a minute. As you can see, this is the document, Bankshire Consul Security Agreement, Moorish Freehold of Financial Services -1. You see the number right here at the top, 2014-049-867. Page 32 of 66. Is how I signed. Pay close attention. Look at the credentials at the bottom of the signature line. Alright? This is what you want to pay close attention to. You see that word? Right there. Blood heir. Now let's look at the credentials after this word, blood heir. Paleo-American, Autochthon, Freehold ancestry of East Asian, Southeast Asian, Native American. Chromosome markers. This is the autosomal 2, 4, 8, 9, and 15. Et al., which means in other more ancient Paleo-American markers of the She, Olmec, and New Trois Khoisan Chichimeca Wisharitari of Mexico, L1 and L2 haplogroups clusters, Washaktun and Negritos, i.e. Negritos, pygmy skulls, mtDNA, L1C1D, Y chromosome, E1B1A8A, Aborigine, American, sanguis typos, O positive, blood type. An ancient god who walks among the dry bones, mentally dead of the valley. I am that I am, the true covenant of blood and the true book of life. That shows you the capacity in which this document was issued by the issuer. Security agreement, which is also backed by 10 troy ounces of silver bullion. As you can see, this is the first page of the same document. Look up in the upper left hand corner, you see the same instrument number, the date, August 28th, 2014. Alright, where it's recorded, and the records of the clerk. Okay, so what am I saying? Anybody who's coming talking about they got claims to this or claims to that, I'm going to show you in this document the collateral, because I know there's many out there making claims that haven't seen the collateral. We're going to go through some supplementary documents after this, but you don't have no fucking blood on the table, you can't make that claim. Only thing you got coming out your mouth is hot air. That's it. Weather records, produce the records comparable or preceding that date, and let's see what you made it as, and let's see the blood. Put the money on the motherfucking wood. That's what we want to see. Other than that, you talking about it's bagged by this and it's bagged by that. We're going to go into some maxims of law to show you why what you're saying cannot be true. Anybody that's making that and they ain't got no blood or dates that precede this. Alright, here's the first page of the security agreement. Alright, you can read it for yourself. Security agreement is pursuant to Bankshire Consul, Moorish Freehold of Financial Services, a perpetual divine charter for the Moorish Private Bank in North America, non-negotiable private agreement, security interest between two parties. Party of the first part. There you go. You can read this, see it for yourself. You can get a downloaded version of this at PulaskiClerk.com. Real estate records. Go to real estate records, put in the instrument number that you've seen, and it'll open up. You can print off a copy for those who don't like looking at computer screens or phone screens for a long time. And it's also in my OneDrive and the entire trust folder. Alright, you can see everything here. This is a party of the first part. United States Secretary of the Treasury is trustee of the United States and 50 corporate states bankruptcies, and presiding as trustee over the agency known as the indigenous United States Department of the Treasury, inclusive of and on behalf of its the insolvent, civility mortu, civilly dead in the eyes of the law, or for various parent corporation known as the indigenous. There you have it. And it says the indigenous corporations, franchisees, subsidiaries of the corporate United States, USA, etc. in the name as the states of, and it goes there. Look at all this stuff for yourself. All of there is international, federal, state, county, parish, and municipal levels. That's everything, people. And all of there is subdivisions, agencies, agents, offices, and officers thereof. All non-Moorish companies. That means all of them. Microsoft, Twitter, Facebook, Walmart, whoever. LLCs, corporations, and any other forms of businesses registered, incorporated, or doing business therein upon the Moorish Freehold. And all United States patented, ins, legal fictions, corporate persons in color of law, in solvent fashion known as U.S. democracy. That's FDR and his New Deal. 14th Amendment. That's the 14th Amendment fraud. U.S. citizen, person, resident, and these patented brands that they have: Negro, Black, Colored, Afro-American, African-American, European, White, Caucasian, Indian, American, Latino, Spanish, Hispanic, Puerto Rican, Asian, Alaskan Native, etc. So when you get time, you can take the time and read this shit yourself. Okay? Alright. Let's go on down here to the party of the second part. This is us. This is the bank. This is Shia Khan, ThunderClan, Old McMoores, as well as beneficiaries of El, Bayday, Al, and Ali, who are elected. They qualify to be beneficiaries of what is set up. Just because you're an El or Bay does not mean we have to accept you. We say you got to meet certain criteria to join us. What you do on your own, that's your own business. You can see this and read this for yourself. This is part of the agreement, y'all. Ten troy ounces. Troy ounces. As there's your money. Here you go. As credit loaned. Okay? I don't have to make up shit. It's right here. Alright? This is what set the record. Acknowledges. It says this is part of the agreement. Acknowledges that DNA, not the BIA. DNA set the precedent for this security agreement. Blood. Alright? Now when I show you these maxims of law, those who've been making all these claims probably gonna shit on themselves. It's not my concern. Right about now, grocery stores are stocked up full of toilet paper. It's not out anymore, so you can get some after you create that mess. Alright, let's get to the collateral. Here's the collateral section. As you can see it for yourself. This was all secured in August of 2014. Blood, birthright, inheritance. Landowners, landlords, land creditors, all land rights, all mineral rights, all water rights, all air, all sky, all space rights. You can see it for yourself. But let's go down here to even something more interesting. Let's look at Article 7. Financial books and records, court cases, and judgments past, present, and future. In any court whatsoever. And all bonds, orders, warrants, and other matters attached thereto or derived therefrom. All traffic citations, tickets, all parking citations, tickets, and all of the debtors' entitlement to transfer assignment rights, and all of the debtors' states of any state, certificates of live birth, numbers, any number, driver's license, social security card, all CUSO numbers except etc. The attached birth name for trade name, trademark purposes, marks, trademark purposes, as enforced by the discretion of the secured party. This is where they're getting ready to take you, people. They're going into biometrics now. That's what the RFID chip is. The COVID ID chip is. These motherfuckers is getting ready to put you in a pod. Real talk. They're going to build a digital version of you that's going to control your living self. We already secured that years ago. Here you go right here, Article 8. Biometrics data, record, proprietary data and technology. You people better go read this thing, man. Because once we close the arc and the shit hits the fan, man, listen. I'm not trying to hear any screams or cries or none of that. Because I've been telling y'all. At that point in time, I'm looking at securing me and mine. And those that saw what I did and went and did the due diligence themselves. Look at Article 9. Transfer or assignment rights of databases and contents. Y'all already know who the debtor is. That's the party of the first part. We're the party of the second part. So when you got time, I strongly advise you to go and read this. You got a lot of people out there, man, take it from bits and pieces of shit I've already done. But guess what? You couldn't do it like me because you didn't have no damn blood on the table. You didn't put your blood lineage on the table. All you had was paper and hearsay. That's it. Alright, when you get time, go check this out for yourself. Here's the supplementary document for what I just showed you. Alright. See the instrument number at the top, 2014-07-1800. You go and look at it. Now, let's get down to the meat and potatoes of this. Alright, you see what it says. Notice of newspaper publication, Banksia Consul, Freehold Financial Services. Boom. Tells you where it is. Charter and security agreement, 2014-049-867. It's now enforceable by public law and operation of law. Contract makes the law, people. And every contract must be supported with lawful consideration. Federal Reserve notes are not lawful consideration. They have no intrinsic value. All you gotta do is go look at the debt clock for that. Same document. You see the instrument number at the top, page 8 of 27, giving them notice that, hey, security agreement and charter has been filed. You took the money, so therefore we're good. You accepted the money, we're good. I gave you the money on the wood, so that made the bet good. All right, I'm finna run and let everybody know, public. This is what this document is talking about. And it tells them, the notice shall read in such manner. International notice to affect everyone. Banksia Consul, Morris Freehold Financial Services, PulaskiClerk.com, real estate, instrument number for all debtors that's contained therein. That's the party of the first part. It tells them the time that it was going to run. It tells them what happens after that. Instrument number 2014-049-867. Become private law between party of the first part, party of the second part. Remember, the contract makes the law. Stated with an instrument number 2014-049-867. It shall now be brought forth as public law in the foreign corporate United States and 50 corporate states democracies after 30 days of notice in a newspaper of general circulation. The contract was brought to the democracy, not the public, but to the democracy. So therefore, as you can see, after October 23rd, 2014, by operation of law, payments of debts and performances of obligations by the party of the first part shall be due and whole to the party in toto, to the party of the second part, as agreed by the party of the first part, instrument number what? Security agreement and charter. This is the highest security interest against party of the first part, and it's a silver bullion backed loan. You saw that in the security agreement. Internationally secured matter. Alright? As the party of the first part is lawfully beholden to the party of the second part, just as the debtor is subject to the creditor. As the primary duty and obligation of all public officers, agents, employees, the various corporate, state, and federal legislative, executive, and judicial branches, and subordinate agencies of the party of the first part, to uphold all the rights of the party of the second part. This pursuant to what? Instrument number. You can go and read this for yourself. I'm not going to stay too long on this. Here you go. Newspaper of general circulation. Boom. This is the affidavit of publishing. Subscribed and sworn. They are the days. Let's get it big so you motherfuckers can see it. Got it? Alright. There you go. What was ran? That. So you can see it. Let's go back up here. Make it bigger so you can see it. Alright, here you go. As you can see, declaration, third party, certificate of non-response. Who received it? And they said nothing. They got it and they said nothing. Let's look up what service by publication is. Definition from Nolo's Plain English Law Dictionary. Serving a summons or other legal document in a lawsuit on a defendant by publishing the document in an advertisement in a newspaper of general circulation. We're going to look that up too. Service by publication is used to attempt to notify a defendant who is intentionally absent, in hiding, or at an unknown address. It's allowed only after the judge has been convinced, based on a sworn declaration, of the serving party's inability to find the defendant after trying hard. Remember, there are no judges. You can only wear the title of judge in a republic. They've been operating as a democracy for the last, 87 years? Since 1933? So they're all corporate administrators. Service by publication is commonly used in a divorce action to serve a spouse who has disappeared without a leaving, affording address, or to give notice to people who might have a right to object to a quiet title action to clear title to real estate. Alright? No objections to the paper. Here you go. Newspaper of record. What is it? A newspaper of record is a major newspaper with large circulation whose editorial and news gathering functions are considered authoritative. It may also refer to a newspaper that has been authorized or maintained by a government to publish public or legal notices, thus serving as a newspaper of public record. There you go. Here it is for the Arkansas Democrat Gazette. Is the newspaper of record in the U.S. state of Arkansas, printed in Little Rock with the Northwest edition, published in Lowell. It is distributed for sale in all 75 of Arkansas's counties. How long has this paper been around? Since 1819. The Arkansas Democrat, 1878. Democrat Gazette, 1991. This paper's been around since the days of the Republic. This was the official newspaper of record for the Arkansas Republic. You can see it for yourself. Right there. Go do your own homework. By virtue of one of its predecessors, the Arkansas Gazette, founded in 1819, it claims to be the oldest continuously published newspaper west of the Mississippi River. The original print shop of the Gazette is preserved at the historic Arkansas Museum in Little Rock. straight out of the Republic, the oldest west of the Mississippi, i.e. Washita territory. This right here is a digital archives collection of the Arkansas constitutions. Alright, this is the first constitution, 1836 Arkansas Constitution. Let's go see what it says about the press. Scroll down. Let's get it large so you can see it. Section 7. That printing presses shall be free to every person, and no law shall ever be made to restrain the rights thereof. The free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak or write and print on any subject, being responsible for the abuse of that liberty. Newspaper of record. Printing was factual. This is the Arkansas 1861 Constitution. During the Civil War. See what it says about printing. Section 7. That printing presses shall be free to every person, and no law shall ever be made to restrain the rights thereof. The free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. 1861 Constitution, Section 7. This is the recent Constitution for Arkansas, 1874. As you can see, it's all capital letters, so it's the corporate state of Arkansas, but of 1874. After the Organic Act of 1871, which made the United States a corporation and turned the District of Columbia into a municipality. Let's see what they say about the printing press. Article 6. Article 2, Clause 6. Excuse me. Liberty of the press and of free speech. Libel. The liberty of the press shall forever remain inviolate. The free communication of thoughts and opinions is one of the invaluable rights of man, and all persons may freely write and publish their sentiments on all subjects, being responsible for the abuse of such right, and all criminal prosecutions for libel. The truth may be given in evidence to the jury, and if it shall appear to the jury that the matter charged as libelous is true, and was published with good motives for justifiable ends, the party charged shall be acquitted. Now I'm going to say this. At the time that notice went in the paper and that security agreement went out, Dustin McDaniel received a security agreement. He was the Attorney General for the state of Arkansas at that time. He received the security agreement. He received the notice in the paper, just like everybody else. John Hickenlooper, who was head of the National Governors Association, for all 50 governors got it. Jay Johnson of Homeland Security, who was the director at that time. President Obama. Jacob Lew, Secretary of the Treasury at that time. Ban Ki-moon, Secretary General of the UN. They all got it. Now, don't you think if that was false in the paper and what was on the public record, there'd be a problem by now? No, it's not. And it's already cured. Birthday of the bank is 6 years old. This August 28th. Think on that for a second. Form 56. Y'all seen this before. Y'all seen all this shit in my prior videos. But apparently some people just don't get it. It's not penetrating through this thick skull that look. First in time, first in line. We're gonna cover this with the maxims. Banksia Consul, identifying number. There it is. You see this? What treaty? There you go. Any instrument number. Any instrument number. Who received it? Let's make it big so you can see it. Internal Revenue Service. Received. When? So they've been knowing about this shit. This is what I'm trying to tell y'all. Y'all can go look at this for yourself. There's the instrument number. Top left. As you can see, this is the New American Encyclopedia, a popular dictionary of general knowledge, edited by George Ripley and Charles A. Dana. Volume 9, Hayne, New Jersey, New York, D. Appleton and Company, London, Little Britain. Roman numerals, the year 1861. Alright, hold on. Alright, same encyclopedia, New American. They have the word heir. Let's look at what it says. Heir, Latin, hares, in law, one entitled by descent and right of blood to lands, tenements, or other hereditaments. Hence, it is an ancient apothegm that God only can make an heir. Are y'all seeing this? Nothing is more common than to hear that a purposes to make or has made be his heir. But this is a mere mistake, or rather, inaccuracy. A may make whom he will his devicee, and this devicee may take the same estate he would take if he were heir, but he cannot take it in the same way, meaning he cannot take it by blood. The heir would take it by descent, and only he can so take. He may be disinherited, but his right of blood cannot be transferred, and therefore the devicee takes only by purchase. For in law, there are but two ways of taking land, one by descent and the other by, let's go up here to the top, purchase. And whatever taking is not by descent is by purchase. But the law itself makes a concession in favor of wills from his desire to carry the will of the deceased into effect, and will construe the word heir as having the broader meaning of successor, if the manifest intention of the testator requires it. And even out of wills, the exact technical meaning of the word is sometimes disregarded in the United States if justice requires that it should be strictly. The heir takes only the real estate. Personals go to an administrator or executor and are distributed by him to the next of kin. Y'all will go in there. I got this encyclopedia, and the OneDrive is in the language folder. Same encyclopedia. Further down, in the Roman civil law, the word heres, which we translate heir, meant that this word does with us in common use, that is, anyone called to the succession by blood, device, or bequest, and whether the property to which he succeeds be fixed or movable. An heir apparent is one who must be the heir if he survived the owner as the eldest son in England or all the children in the United States. Blood, people, only God can make an heir. He's the author of the bloodline, the Most High Creatress, creator of the heavens and earth. What do y'all not understand about that? Bouvier's Dictionary of Law. Bouvier's 1856 Law Dictionary. We're going to talk about some maxims so y'all can see these things for yourself. What is a maxim? Established principle or proposition. A principle of law universally admitted as being just and consonant with reason. Maxims in law are somewhat like axioms in geometry. They are principles and authorities, part of the general customs or common law of the land, and are of the same strengths as acts of parliament when the judges have determined what is a maxim, which belongs to the judges and not the jury. Terms de ley, just terms of law. Maxims of the law are holden for law, and all of the cases that may be applied to them shall be taken for granted. The application of the maxim to the case before the court is generally the only difficulty. The true method of making the application is to ascertain how the maxim arose, and to consider whether the case to which it is applied is of the same character, or whether it is an exception to an apparently general rule. The alterations of any of the maxims of the common law are dangerous. The following are some of the more important maxims. All right. Here you go. Let's see what it says about the record. Nemo potest contra recordum verificare per patria. No one can verify by the country against a record. The issue upon a record cannot be tried by a jury. Quod per recordum probatum non debet esse negatum. What is proved by the record ought not to be denied. Recorda sunt vestigia vestutatis et veritatis. Records are vestiges of antiquity and truth. Let's see what it says about blood. Jura sanguinis nullo jure civili derimi possent. The right of blood and kindred cannot be destroyed by any civil law. Let's see what it says about heir. Heredum. Deus facit non homo. God and not man make the heir. Heredum est nomen collectivum. Heir is a collective name. Heires est nomen juris. Filius est nomen naturae. Heir is a term of law. Son, one of nature. Heires est ad jure proprietatis ad jure representationis. An heir is either by right of property or right of representation. Here it is again. Heires est wierdo persona cum antecessore. The heir is the same person with the ancestor. Heires, heredis, me es meus heires. The heir of my heir is my heir. in restitutionem, non in panem, heres succeeded. The heir succeeds to the restitution, not the penalty. Restitution in post-millennial. You heard me say that several times, people. Here it is again. Solus Deus heredem facit. God alone makes the heir. Let's see what it says about being first. Qui prior est tempore, potior est iure. He who is first or before in time is stronger and right. Here it is. Quod nullius est in ratione naturali occupante conceditor. What belongs to no one naturally, as in natural law, belongs to the first occupant. Look at this one. Quod prius est verius est, et quod prius est tempore potius est iure. What is first is truest, and what comes first in time is best in law. Let's see what it says about free. Iniquum est ingenius, omnibus non esse liberum rerum suarum alienationem. It is against equity to deprive free men of the free disposal of their own property. If the first occupants of the land are the owners of the land and its resources, then who's the one that should be disposing of them? Shouldn't it be the first occupants? Let's see what it says about soil. Aqua sidit solo. The water yields or accompanies the soil. The grant of the soil or land carries the water. I'm going to go in the Black's Law Dictionary and show you the rest of this maxim because Bouvier's doesn't have it on here. But there's another part to this. Cujus est solum, ejus est usque ad caelum. He who owns the soil owns up to the sky. Look at these two. Quisquid plantator solo, solo sidit. Whatever is affixed to the soil belongs to it. Quisquid plantator solo, solo didit. Whatever is affixed to the soil or the realty thereby becomes a parcel. Look at this one. Quod solo in edificator solo sidit. Whatever is built on the soil is an accessory of the soil. Look at these. Solo sidit quod solo implantator. What is planted in the soil belongs to the soil. Says it again here. So it gives two versions. I hope y'all understanding where I'm coming from on this. Y'all need to be getting this shit. Let's see what it says about proof. Affirmati non negante incumbit probatio. The proof lies upon him who affirms, not on him who denies. Claim and proof of claim, people. Claim and proof of claim. When they make these claims, make them prove it. And what is proved by the record ought not to be denied. And he who was first in time is preferred in right. And blood is the highest of claims. It's an act of God. Oh, we're not done, man. Like Ice Cube say, it ain't over, motherfucker. Look at this one. Cum ad son testimonia rerum quid opus est verbis. When the proofs of facts are present, what need is there for words? Look at this one. Ei incumbit probatio qui decit non qui negat. The burden of the proof lies upon him who affirms, not he who denies. Check this one out. Look at this one. Semper necessitas probandi in cum qui agit. The claimant is always bound to prove. The burden of proof lies on him. Let's see what it says about facts. Cum ad sunt testimonia rerum quid opus est verbis. When the proofs of facts are present, what need is there of words? Look at this one. Ex facto jus oritur. Law arises out of fact. That is, its application must be to facts. Ho, ho, ho. Look at this one, y'all. Facta sunt potentiora verbis. Facts are more powerful than words. Claim, making all these claims. DNA is called incontrovertible evidence, y'all. You can't argue against it. It's established as a fact. Y'all gonna learn, man. Y'all gonna learn today. Y'all gonna learn today. Check this one out. Common, everybody should know this one. Ignorantia facti excusat. Ignorantia juris non excusat. Ignorance of facts excuses. Ignorance of law does not excuse. Here you go. In judicio non creditor nisi juratis. In law, none is credited unless he is sworn. All the facts must, when established by witnesses, be under oath or affirmation. Alrighty, y'all. Black's Law Dictionary. Revised 4th edition. 1968. Let's get into it. Alright, y'all. This is talking about the term illires. In Roman law, the heir or universal successor in the event of death. Let's go down here and see what it says about it in common law. In common law, illires means an heir, he to whom lands, tenements, or hereditaments by the act of God and right of blood to descend of some estate of inheritance. Act of God. Here it is again, talk about an act of God. Look at this maxim, y'all. Necessitas inducit privilegium quod iura privata. Necessity gives a privilege with reference to private rights. The necessity involved in this maxim is of 3 kinds. Number 1, necessity of self-preservation. 2, of obedience. And 3, necessity resulting from the act of God or of a stranger. Y'all just saw that an heir is considered an act of God. Only God can make the heir, y'all. Y'all gonna eventually put this shit together. I'm not waiting. I gotta go. This is Black's Law Dictionary, y'all. As you can see, 2nd edition, 1910. Let's get into it. Let's look at this maxim, y'all. Cujus est solum, eius est usque ad coelum. Whose is the soil? His it is, up to the sky. He who owns the soil or surface of the ground owns or has an exclusive right to everything which is up on or above it to an indefinite height. Look at this other maxim. Cuius es solum, eius es usque ad coelum et ad inferos. To whomsoever the soil belongs, he owns also to the sky and to the depths. The owner of a piece of land owns everything above and below it to an indefinite extent. Look at this maxim here. Whose right it is to institute, his right it is to abrogate. Which means whoever gives also has the right to take. Let's see what it says about estate of inheritance in Black's Law Dictionary, 2nd edition, 1910. Estate of inheritance, a species of freehold estate in lands, otherwise called a fee, where the tenant is not only entitled to enjoy the land for his own life, but where after his death it is cast by the law upon the persons who successively represent him in perpetuum in right of blood according to a certain established order of descent. They're talking about heirs again. Here we go. Heirs in Roman law. Let's go see what heir is or heirs means in common law. Here it is again. Black's Law Dictionary, 2nd edition, 1910. In common law, an heir, he to whom lands, tenements, or hereditaments by the act of God, only God can make an heir. God and not man makes the heir. Only God makes the heir. Y'all seen these maxims. Here it is. And right of blood do descend of some estate of inheritance. Here it is in Black's Law Dictionary, 2nd edition, 1910. The maxim we saw in Bouvier's Dictionary of Law, 1856. Iura sanguinis nullo iure civili derimi posset. The right of blood and kindred cannot be destroyed by any civil law. I repeat, the right of blood and kindred cannot be destroyed by any civil law. Man, look at this. Non-use, sed sesina, facit stipitum. Not right, but seisin makes a stock. It is not a mere right to enter on lands, but actual seisin, which makes a person the root or stock from which all future inheritance by right of blood must be derived. Look at this. Strangers. This is in Black's Law Dictionary, 2nd edition, 1910. Strangers, by this term, is intended third persons generally. Thus, the persons bound by a fine are parties, privies, and strangers. The parties are either the cognizors or cognizees. The privies are such as are in any way related to those who levy the fine and claim under them by any right of blood or other right of representation. The strangers are all other persons in the world, except only the parties and privies. In its general legal signification, the term is opposed to the word privy. Those who are in no way parties to a covenant. Remember how I signed the paperwork? The true covenant of blood in the security agreement? the true covenant of blood, nor bound by it, are, let's go up here, also said to be strangers to the covenant. Black's Law Dictionary, 2nd edition, 1910. Maxim of law on land. Tierra, manens, vacua, occupante conceditor. Land lying unoccupied is given to the first occupant. There you go. We're back at Black's Law Dictionary, 4th edition, revised 1968. Look at this maxim. Cuando duo jura concurrent in una persona, yecum est axi essent in diversis. When two rights concur in one person, it is the same as if they were in two separate persons. That means a person can have more than one right, and they cannot say because it's in the same person that he got to choose one. No, if they all exist within you, you have more than one right on a certain thing, they got to grant it to you. You don't have to choose shit. Look at this. Where two rights concur, the more ancient shall be preferred. First in time, first in line. Y'all will figure it out. Here you go again. Quod prius est verius est, et quod prius est tempore potius est jure. Black's Law Dictionary, 4th edition, revised 1968. What is first is true, and what is first in time is better in law. Here we go again. Quod nullius est, et ratione naturali occupanti conceditur. That which is the property of no one is, by natural reason, given to the first occupant. First in time, first in line, and blood, occupation of the land. Listen to what this says about natural rights. Black's Law Dictionary, 4th edition, 1968. Natural rights are those which grow out of the nature of man and depend upon personality, as distinguished from such as are created by law and depend upon civilized society. Or they are those which are plainly assured by natural law. And it cites a case, Borden versus State, Arkansas Supreme Court, 11, Arkansas 519, 44, American, and I'm not sure what the DEC is for abbreviation, 217. Or those which by fair deduction from the present physical, moral, social, and religious characteristics of man he must be invested with, and which he ought to have realized for him in a jural society in order to fulfill the ends to which his nature calls him. Such are the rights of life, liberty, privacy, and good reputation. Constitutional Law, 3rd edition. Then it goes into civil rights. Look at this, y'all. This is some of the various bodies of law. With reference to its origin, law is derived either from judicial precedents, from legislation, or from custom. As to the different kinds of law, or law regarded in its different aspects, see absolute law, adjective law, administrative law, admiralty law, law of arms, bankrupt law, canon law, case law, law of citations, civil law, commercial law, common law, constitutional law, criminal, custom, ecclesiastical law, enabling statute, equity, law of evidence, law Law of evidence. Genetics. Rules of evidence 702. Law of the flag. Admiralty. The flag being flown dictates the contract. Foreign laws. Forest law. International law. Local law. Maritime law. Law of marquee. That's what the police be doing on these streets. Martial law. Mercantile law. Military law. Moral law. Municipal law. Natural law. Laws of Oleron. That's the law of the sea. Y'all need to go and study that. I talked about that in one of my lectures. Organic law. Parliamentary law. Penal laws. Personal law. Positive law. Private law. Probate. Prospective law. Public law. Remedial statute. Retrospective law. Revenue law. Law of road. Roman law. Special law. Staple. Law staple. Statute, substantive law. Unwritten law. War. Wisby. Law, see. Laws of Wisby. Written law. Legal notice. Such notice as is adequate. In point of law. Such notice as the law requires to be given for the specific purpose or in a particular case. Knowledge brought home to a party in a prescribed form. Well, this concludes my walk down. Once again, showing y'all what's what and who's who. And showing y'all, man, how to make these folks making these claims and shit prove it. But accepting what the hell they saying, man. They can put the damn money on the wood, man. That's what it is. And so, you know, y'all motherfuckers know which ones be out there, man, biting, stealing and thieving and shit, and trying to act like they done came up with something off of my shit. But like I said, man, make them put the damn record on the wood. Boys that claiming they this and claiming they that, I done already showed you. There you go. Incontrovertible evidence, can't be denied, can't be refuted. It's what it is. It's the record. Y'all see everything and how I did it by blood. So Pimp C told y'all, man, let me see it. Tell them folks, man, Pimp C, hey man, Pimp C told me to tell y'all, let me see it. For real. So that's all, man. Peace and love. I'm out. Ashe.